Hello friends, welcome to our channel Khatri Steno. Subscribe our channel for more dictations on daily basis. Get ready for the dictation. At every stage, these will be revisions and writs to stall and defeat the prosecution. Stop. Top lawyers are engaged. Stop. Some or other point is raised and the litigation goes on endlessly, thus defeating the true objective of the criminal prosecution. Stop. Unfortunately, the courts too have come to attach more sanctity to procedure, forgetting the principle underlying sections 462 465 of the Code of Criminal Procedure 1973, namely, any and every infraction of procedure provision does not vitiate the final order passed, and that only that violation which causes prejudice may constitute a ground for disturbing the final order passed. Stop. Indeed, it must be said that criminal judicial system in this country has proved totally ineffective, particularly against the rich, the influential, and the powerful. Stop. It is effective, if at all, only against the poor, the destitute, and the undefended. Stop. We do not, however, think it necessary to stress any further the prevalence and pernicious role of corruption in our body politic, as it is an obvious and indisputable fact. Stop. Inadequacy of the existing law and the proposed measures to tackle the evil of corruption. It is true that the Prevention of Corruption Act 1988 provides for confiscation on assets of public servant which are in excess of his known source of income, but such forfeiture can come about only after the public servant is convicted for the relevant offense. Stop. There is also in vogue a pre-independence law, that is criminal law amendment ordinance bracket 38 of 1944 bracket clause, which provides for attachment of properties of a public servant who is accused of corruption. Stop. But here again, the confiscation can come about only pursuant to and on the basis of conviction of corruption. Stop. Similar is the position under the Prevention of the Money Laundering Bill 1998, introduced in the Parliament recently. Stop. The bill defines the expression money laundering to mean owning, possessing, or otherwise dealing in the proceeds of the crime, and confiscation of proceeds of crime is possible only after a person is convicted of one or the other offense mentioned in the schedule to the bill. Stop. Part 5 of the schedule mentions some of the offences created recognized by the Prevention of Corruption Act, but quite significantly, the offence of possession of disproportionate assets dealt with under clause within bracket E of subsection within bracket 1 of section 131 is not one of the offences mentioned in the schedule. Stop. Perhaps the said offence did not fit into the scheme of the bill. Stop. Be that as it may, the fact remains that there is no law in force in this country providing for forfeiture oblique confiscation of the ill-gotten assets oblique properties of the holders of public office, similar to SEFEMA. Stop. Merely sending the corrupt holders of public office to jail is no remedy. It is no solution. Stop. it doesn't really hurt them stop unless their ill-gotten assets are forfeited to the state. The canker of corruption to really tackled stop. Hence, the necessity of the proposed measure stop. As a matter of fact, this approach was recognized by Parliament more than 20 years ago in the case of smugglers and violators of foreign exchange laws. Stop.